Hello and welcome to our lecture on the court packing plan and the switch in time that saved nine. This is laying the groundwork for our understanding of how the Supreme Court changes from the direct and indirect effects doctrine and stream of commerce doctrine interpretation to the substantial effects doctrine interpretation of the Commerce Clause. So in our last lecture, we discussed some of the problems leading up to FDR's conflict with the Supreme Court over New Deal programs. The Supreme Court struck down some of those programs, first because Congress had, in its view, impermissibly delegated its legislative authority to the president, and secondly, because the president was attempting to regulate things that were not interstate commerce, things that were wholly local in character, and those things were only properly regulated, if they were going to be regulated, by the states. So let's go on and have a look at what happened as a result of these conflicts. So the switch in time refers to the Supreme Court's response to FDR threatening the court with his court packing plan. And it began in a case, interestingly enough, that doesn't have to do with federal regulation of interstate commerce at all. It began in a case called West Coast Hotel versus Parrish in 1937. We're going to discuss this case more during week 7 when we talk about the state's police power and state efforts to regulate manufacturing and labor. But in this case, Washington State attempted to regulate the wages and working conditions for children and women in the hotel industry. Elsie Parrish was a maid in the West Coast Hotel, and she asked for back wages and for overtime worked, and the West Coast Hotel refused. So she sued, and West Coast Hotel made the argument that Washington could not regulate this because it was a private contract between Elsie Parrish and West Coast Hotel, which was beyond the scope of state power to regulate. The court rules that Washington State can regulate the wages and working conditions of women and children engaged in the hotel industry. And then the court decides a pivotal case, NLRB, or National Labor Relations Board, versus Jones and Laughlin Steel in 1937. It then goes on in a case called United States versus Darby Lumber in 1942 to reaffirm and to reassert the substantial effects doctrine. And finally, the court decides a case called Wickert versus Filburn, in which it extends the substantial effects doctrine out to include things that are wholly local in character, that Congress can regulate things not intended for the interstate market if they have a substantial effect on the market. Okay, so let's talk about National Labor Relations Board versus Jones and Laughlin Steel. This was the case in which the Supreme Court switched its interpretation, or began anyway, the switch of interpreting the Commerce Clause in favor of New Deal programs. The New Deal programs up until this point, many of them had been struck down as unconstitutional, and FDR is hanging on his last thread. The Supreme Court's getting on his last nerve, and the court finally changes its view of the Commerce Clause to uphold the regulation of the steel industry. So the question here was, may Congress pass legislation that allows workers to organize and create an agency to protect their rights as workers? Supreme Court says yes, and by a 5-4 decision. Now, you should note that the National Labor Relations Board had made it legal for labor to unionize, to organize for the purpose of bargaining collectively. Up until this point, the federal government could not legalize or make it illegal for workers, laborers to organize into unions for the purpose of bargaining collectively, because as we know, labor is not interstate commerce. So the states were the ones that could regulate that. And the states, many of them, outlawed unions. They said that unions were illegal because they were illegal attempts to interfere with private contractual arrangements. At one point, unions had attempted to organize a strike against the Pullman car company, and it affected transit throughout the nation. It brought the nation to a standstill. Eugene V. Debs is also the socialist candidate for president. He was prosecuted for disturbing the public order and attempting to create chaos in our national transportation system. And he was sent to prison by a judge named William Howard Taft, who later became Chief Justice of the Supreme Court. So, you know, you might see where the Supreme Court would say, well, the federal government has no business legalizing unions. But the Supreme, you know, because unions deal with labor, and labor is local in character, and the state should do it. But here's what the court said. Congress has the power to regulate anything that may affect interstate commerce, and stoppages in labor certainly do prevent goods from entering the interstate market. While some activities may seem to be simply intrastate, if they are closely related to interstate commerce, then Congress cannot be stopped from regulating them. The court changed its mind about whether labor had an effect on commerce. Now, certainly, under the direct and indirect effects doctrine, labor only indirectly affected commerce. In this case, the court says that labor directly affects commerce. So here's a quick review. So Gibbons versus Ogden in 1824 defines commerce for us. It says commerce is intercourse, navigation is part of commerce, and it is the transacting across state lines. In E.C. Knight in 1895, the court says manufacturing is not commerce. It doesn't involve transacting across state lines. And it says Congress can regulate things that directly affect commerce like navigation, but not things that indirectly affect like manufacturing. In Stafford and Swift, the two cases involving the stockyards and the movement of cattle across the country, the court articulates the stream of commerce doctrine. And it says, by the way, that Congress can regulate anything that has entered the stream of commerce up until the point that it drops out of the stream of commerce for an endpoint sale. Schechter Poultry dealt with that endpoint sale, and the court ruled against Congress regulating the butchering of chickens wholly intrastate. Carter versus Carter Cole dealt with mining, said that Congress can't regulate it because the flow of interstate commerce hadn't begun yet. So Schechter Poultry, chickens are intrastate, their butcher is intrastate because the stream of commerce has stopped. Congress can't regulate mining in Carter versus Carter Cole, and it's local, mining is local because the flow has not begun yet. One it had stopped, the other it hadn't begun. Commerce, it says, is intercourse for the purposes of trade. The extraction of coal is not that. And finally, in NLRB versus Jones and Laughlin Steel, the court says that Congress can regulate anything affecting commerce. And it says affecting commerce equals any dispute leading to the obstruction of commerce. We see a strong shift here in NLRB away from direct and indirect effects and toward substantial effect. Although the court may not use the word substantial, it does say Congress can regulate anything affecting commerce, including a labor dispute that obstructs the flow of goods in the interstate market. Well, that brings us to the United States versus Darby Lumber. This involved the imposition of the Fair Labor Standards Act provisions on a lumber company. Now, lumber, of course, would be manufacturing, right? They're cutting down trees and then processing them, and then selling them to people who are going to sell them to people who are going to build things with it. So we're talking about the extraction of raw materials. A thing up until this point, the Supreme Court has said, is manufacturing is wholly local in character, only indirectly affecting commerce, and Congress can't regulate. Congress decides to regulate. And the question before the court is, does Congress have the authority to invoke the Fair Labor Standards Act under the Commerce Clause to regulate the lumber industry by imposing things like minimum wages and working conditions? The court says, yes, Congress can. Oh no, this is the death of direct and indirect effects doctrine. The court says that, yes, Congress can regulate manufacturing. Why? Regulations of commerce that do not infringe on some other constitutional prohibition are within congressional power. Wait a second. Some other constitutional prohibition? Up until this point, the court has said, yeah, it's infringing on the state's power to regulate. Well, let me give you some notes on Darby Lumber here. First of all, it explicitly overruled Hammer. Now the court is looking at labor and manufacturing as substantially affecting commerce. I know it's a very subtle change from direct and indirect to substantial, but it's a huge change in terms of what Congress can regulate. And Darby explicitly overrules Hammer. The court says that Congress can do anything within its power to regulate commerce, and that includes anything that substantially affects commerce, like labor and manufacturing. And this is another death knell for the 10th Amendment. Suddenly, a thing that had been left to the states to regulate, now the federal government can regulate. Stone squares clearly with Marshall's cooperative federalism. Justice Stone says that the states are sovereign, but the federal government has the power to regulate commerce, and it can do anything within that power to regulate it, even things that are substantially related but are not in fact commerce. And this decision lasted for about 25 years. It hasn't been explicitly overruled. For 35 years. For 35 years after Darby Lumber, the federal government never lost a Commerce Clause case. All right, thank you very much for your attention, and we will move along.